Welcome to this special edition of Staying Ahead of the Curve. I'm Jeff Snyder with Camac Retirement Group. And joining me now to discuss the Department of Labor fiduciary rules, Alex Ryan and David Olstein. Guys, thanks for joining us on the show today.
Thank you.
Hi, Jeff. Good to be with you.
Thank you so much. And Alex, you had an opportunity. It's been about a week since the new rules have been released. I know that you and your team have really started to dig into them, 800 pages worth. What did we take away from this Department of Labor rule?
Oh, Jeff, we're taking away a lot, and we will have things to take away for a long time. We've had it a week. We are still unraveling it, still figuring out what it means, still taking it apart. It is occupying our thoughts, our days, our nights. To put it plainly, it is the single most consequential development, I think, in the retirement services space since the enactment of ERISA. Very plainly put, the Department of Labor has really redefined what it means to be an investment advice fiduciary for purposes of providing investment advice to ERISA plans and to IRAs. With that, the department has issued some new exemptions that will apply to financial services providers that are in the business of providing investment advice. And it's also tinkered with some existing prohibited transaction exemptions to bring those sort of current with what the department has done in terms of redefining what it means to be an investment advice fiduciary.
And David, I know you have really dug into this. What do we take away in terms of why the Department of Labor has done this?
Well, the retirement landscape has changed rather dramatically since ERISA was enacted. The existing regulations, the regulations that are being replaced, were issued shortly after ERISA's enactment. And back then, retirement assets were generally held in defined benefit plans. And that had a few consequences for plan participants. Because they were held in defined benefit plans, it meant that they were typically managed by investment professionals. And it meant that participants were protected in a variety of ways, both through the expertise of the people who were exercising investment authority. They also had protection against investment losses because of the way defined benefit plans operate. The employer is required to fund the plan and effectively bears the investment risk. So that if there are losses over time, the employer maintaining the plan has to make up those losses through their own contributions. And finally, participants are protected through the ERISA statute, which imposes fiduciary duties on the people who manage the assets of the plan and gives participants recourse to the courts in the event that those fiduciaries don't live up to their statutory obligations. Fast forward 40 years and things are quite different now. You have money now primarily going into 401k plans and defined contribution plans and IRAs where the individual is responsible for investing, making the investment decisions, and they're going to bear the risk of loss because their assets are now held in account rather than this just general pool where you have an employer that serves as a backstop. And so now when you have assets being managed by people who are not as sophisticated as the investment professionals who manage defined benefit plan assets, the thought was that the participants were not being adequately served by the existing rules. And the thought was that that there were too many instances where there were people who were kind of taking advantage of participants and were operating under conflicts of interest, and the Department of Labor wasn't able to effectively enforce ERISA's fiduciary standards against those advisors because of the very narrow definition of investment advice that was adopted many decades ago.
So, Alex, we talked a little bit about who this applies to, but I want to go into more detail. Who is impacted by this new rule?
The short answer is that virtually anybody that touches retirement assets in the private sector may be affected by the rule. The more nuanced answer, Jeff, is that the primary impact of the rule is going to be with regard to the financial services community entities that heretofore have not typically been deemed or thought of as ERISA or IRA fiduciaries. And so, these are folks like the broker-dealers, product distributors, certain investment consultants, insurance representatives, folks selling insurance-related products. Because of the new definition of what it means to be a fiduciary for purposes of providing investment advice, that definition is far more encompassing than the current framework that we've been operating under for the last 40 years. So that is very likely to pull in a whole host of financial services providers that have not previously been part of that group. On the other side, from the plan participant side, the plan side, IRA owners are now going to have certain assurances in contractual agreements with financial services providers, again, with the broker dealers, with insurance folks, plan participants in 401k plans, for example. They are going to have available to them a different standard of care that attaches to fiduciary status that folks that are within this larger group will be part of. So really, it's very encompassing, and it's very likely to affect a wide swath of people.
So that's the who. And David, what is the impact? I mean, I know it's early, we're a week in, but we knew it was coming for many years. That this has been in the kind of being worked on for a long period of time. In your early estimation, what is the impact to the industry of this new regulation?
Well, it is still early, but the impact, at least in the short run, is it can raise the cost of providing certain services, particularly at the retail end of the retirement services market, because now that if you're trying to market products to participants in plans and IRA owners, and if you're a fiduciary, that has some impacts. It affects the standard of care. Many brokers now are able to operate under kind of limited liability arrangements where their contracts with the IRAs or the plans include exculpatory provisions, which wouldn't be enforceable against ERISA fiduciaries. In addition, if you're a fiduciary, the general rule is that you can't provide advice under circumstances where the recipient acting upon that advice would result in you receiving additional compensation. There are these rules in place that prohibits fiduciaries from taking certain actions that benefit themselves. And so the choice faced right now is whether to restructure your compensation so that you don't have that same kind of built-in conflict, or the alternative is to structure arrangements to fit within a prohibited transaction exemption, which Alex mentioned. There are exemptions that have been out there for a long time to deal with particular types of investments in conflict of interest situations. For example, the use of affiliated broker-dealers to effect or execute securities transactions. And there have been an exemption in place that allows insurance agents to receive commissions in connection with the marketing of annuities and other insurance products. Those exemptions have been extensively revised as part of this process. In addition, the Department of Labor has proposed and now granted additional exemptions which are designed to allow brokers, agents, pension consultants to continue to use the existing business model under which they're compensated through receipt of commissions and revenue sharing and similar transaction-based compensation.
So it's really a domino effect. And Alex, how do you define investment advice? I mean, that's something that, we've always wrestled with that as an industry, but now this really brings everything to bear. How does the new rule define investment advice, and how do you define that?
It's a great question, and in fact, David and I were talking about that very issue outside the studio just a few minutes ago, and as applied to several scenarios, we were able to conjure up as we often do. But the truth is that really is at the heart of this initiative. A recommendation is really the linchpin for fiduciary status as an investment advice provider. If you don't have a recommendation, that ends the analysis right there. it will be something that will develop over time, but the clearest definition that we have right now that's in the rule is that a recommendation is a suggestion by the provider that the recipient take or refrain from taking a certain action with regard to investments. So it is action-oriented. The definition was changed a little bit from the proposal in response to comments from the financial services provider community. But even that is not a simple definition. And what does a suggestion mean? What does taking action mean? These are all things that are going to get worked out in the weeks and months and years ahead.
Yeah, I'd like to expand on that briefly. What the Department of Labor has done is they've broadened the types of recommendations that are considered investment advice. For example, now a recommendation as to whether or not to take a rollover, to roll over funds from your 401k plan into an IRA. That's now considered investment advice, where previously it was not. And they've also expanded the type of context in which these communications result in the imposition of fiduciary status. Under the old rules, it was very difficult to become an inadvertent fiduciary by making just an offhand suggestion or recommendation. Under the old rule, in order to be considered an investment advice fiduciary, you needed to be providing advice on a regular basis. Under the new rule, even a single communication or recommendation can trigger fiduciary status. So it's really a change in both substance, broadening the types of subjects that are considered investment advice, as well as context. So the end result, though, is that particularly those people involved in marketing investment products are much more likely to be considered fiduciaries, under the current rule than under the old rule.
And you bring up a great point. And Alex, I want to ask you a question about suitability. And David mentioned rollovers. So as a consultant advisor, I'm out there talking to plan sponsors. We see people leave the program, roll over to an IRA. Based on what, at least I'm picking up in terms of the new rule, there's some fiduciary responsibility in terms of advising people to move out of a retirement plan where there could be cheaper investments and move into something that could be considered to be a little bit more expensive in an IRA account. So just want to get your sense on that perspective as well.
You've hit on a great point, and it's really one of the tenets or the drivers of this regulatory package. IRA rollovers, as you know, have become a much bigger deal in recent years. The IRA market has really ballooned, and we've seen a lot of rollover activity. There has been some uncertainty in the marketplace about the extent to which fiduciary status attaches to rollovers. Not anymore. Under the new regulation, rollover recommendations are very clearly going to have fiduciary status attached to them. That's plainly set forth in the text of the regulation. So if you are a provider that is in the rollover space, where prior to now there may have been some question about your status as an ERISA fiduciary and a fiduciary under the code for IRAs, that is no longer going to be the case.
So, David, let's change gears just a little bit. If I'm a financial advisor providing advice, how do I determine whether my compensation structure is going to actually pass muster under these rules? I'm a fiduciary now, and clearly there are some rules now about compensation and what it means to be a fiduciary. I wonder if you could expound upon that a little bit.
Well, again, you start with the principle that if you're a fiduciary and you make investment recommendations, that you would be engaging in a prohibited transaction if a recipient of the advice acting upon that recommendation would cause you to receive additional compensation, unless an exemption is available. So usually there are two basic models for compensating investment advisors. There's kind of a level fee, a model where an advisor may get compensated based on a percentage of assets in a portfolio that they're advising, and then there's the commissions-based model where they get compensated on a transaction by transaction basis. And if you're now a fiduciary under the new rule, the only way to use the commission-based model is to comply with an exemption. And one new exemption that's available is known as the best interest contract exemption. And that does allow investment advice fiduciaries to IRAs, to individual participants and beneficiaries in plans where the participants make their investment decisions, as well as fiduciaries of small plans. If you're advising them, you can use the best interest contract exemption. There are a lot of conditions. From the title, one of the requirements is to make some contractual undertakings. If you're advising an IRA, one thing that's required now is that you have to contractually commit to adhere to certain standards of conduct, known as the impartial conduct standards, and those generally reflect the standards of conduct imposed on ERISA fiduciaries. So in this respect, this exemption and some of the changes to other exemptions close a very significant gap that was built into the ERISA statute, where participants in employee benefit plans were protected by these fiduciary rules that impose various standards on the people who manage money in pension plans or provided investment advice, whereas owners of IRAs did not have those protections. So the best interest contract exemption will help close that gap, because advisors relying on that exemption will now basically have to adhere to the same standards of conduct that ERISA fiduciaries have to adhere to. And moreover, because in the case of IRAs or non-ERISA plans, you have to incorporate these standards into a contract, that means that the IRA owner will now have a basis for suing if you don't live up to those standards.
So it wouldn't be a government regulation without a new acronym. Alex, we've got the BIC, Best Interest Contract. We just want to get your perspective on how this is all going to work. I know, again, just context, this is 1 week into the new regs, but wanted to get your sense, kind of expounding upon what David talked about.
Well, that's right. It is new, and we're still figuring it out, and more importantly, our clients, the financial services community, they're still figuring it out. We're all working together to sort of, see how this works. It sounds sort of simple when you look at the parts of it, but when you get a little bit closer, when you sort of start looking at it from different angles, it does get a little more. It does get a little more complicated. We were happy to see that the comments of the provider community, the financial services provider community, appear to have been taken into account in the issuance of the final rule. There were a number of conditions that were attached to the proposal itself that have been changed, in some cases abandoned altogether. For example, ERISA plans no longer have to be parties to a bilateral contract in order for a provider to rely upon the best interest contract exemption. There was, although that remains for IRAs, the contract requirement remains for IRAs. There was also originally a condition that the contract had to be in place before any advice could even be given, which didn't make a lot of sense logically, given the way these relationships come together. That requirement is now largely gone, and there's a negative consent procedure in place so that existing IRA and provider relationships can accommodate reliance on the BIC. So there are a lot of aspects to it that we think are going to make it easier for the provider community to comply with it. But there are, to be sure, some challenges, particularly in the area of some of the disclosure requirements, which have been softened or toned down in the final version, but are there nonetheless. Fortunately, and we can get into this a little more in a bit, fortunately, there is a little bit of lead time here, so the financial services provider community has some time to get ready.
So we've been talking, David, about ERISA and ERISA plans, but there is potentially impact to our friends in governmental plans. Can you maybe talk a little bit about the application of these rules to governmental plans who typically follow ERISA best practices?
Sure. Well, I mean, they're not directly impacted because governmental plans are generally exempted from the fiduciary provisions of ERISA. That said, some states incorporate a mini ERISA statute that imposes fiduciary standards on people who manage those assets. The statutory provisions typically will apply to, the investment board, the state investment board. It's usually less clear whether service providers, third-party service providers, are subject to those standards. But frequently, the governmental plan fiduciaries who retain service providers will seek to impose similar obligations just by contract. So in some respects, governmental plans already have experience with imposing fiduciary requirements by contract, and if anything, the increased use of the best interest contract exemption will probably mean that governmental plans will have greater leverage in terms of negotiating the same types of contractual protections that these proposals would extend to IRAs. So I think what you'll see is that to the extent that other, either ERISA-covered plans or IRAs are gaining protections, you're going to have governmental plans seek, the same types of protections as well.
It's really going to be interesting. And changing gears a little bit, Alex, we've spent a good part of the interview talking about the nuts and bolts, but talk a little bit about the effective date of these newly amended rules.
That's very important in some ways, perhaps the most important question, right? If you don't know when a rule goes into effect, you don't know that you have to begin complying with it. And I actually have to keep referring to my notes because of the staggering impact. Technically, the rules itself are going to be effective in a couple of months. However, there is a delayed application of the rules, and that has a couple of pieces to it. The revised definition of investment advice fiduciary goes into effect next April of 2017. And certain parts of the BIC exemption, some basic elements of the BIC exemption, also go into effect on that same date, April 10th, 2017. However, recognizing that there's a longer sort of ramp-up period for compliance with the BIC, that does not go into applicability until January 1, 2018. So there is some running room here for folks to get ready and spend some time evaluating their models and figuring out what they need to do in order to come into compliance.
So it stands to reason that now is the time to begin to plan, to think about all the nuances, all the things that you're going to have to do potentially to change as an organization. And if you're a plan sponsor, maybe asking the pertinent questions of your service provider partners. Gentlemen, thank you so much for sharing your views on the new rule, and maybe we can check in a few months to see how things are progressing.
That would be fun, Jeff. Thanks for having us.
Thank you.